Why do we need warrant of arrest? Why is it necessary?
Just to know the reason why he's being arrested, because that's warrant of arrest.
To know the reason why he's being arrested. Must he know the reason?
Yes, sir.
Why?
Because constitutional right to know the reason why he's being arrested.
She said, and I agree with her, the essence of the warrant of arrest is for the person to know the crime against him. And I asked, must he know it? They said, yes, it's a constitutional right. Now, if an arrest can be made without a warrant, where warrant is required, and then the arrest will not be voided, do you now say that this warrant of arrest is inconsequential? Or is just a mere window decoration? Do you understand my question? Right. Let me give you a scenario. You know, maybe let's say like we are in a community here now. You see somebody running away, and then all of a sudden you also see people pursuing him, and they say, he has killed somebody, he has killed somebody. As a citizen, what are you supposed to do? To assist, right? Yes, sir. Right. To help and arrest that person. At the time you are arresting him, were you thinking of warrant? No, sir. You're not thinking of any warrant. Now, what is the essence of the arrest warrant if some arrest, or even if you arrest without warrant, it will still be valid? Why would you have that under the law? Why would the law provide for it?
So you can say when there is necessity or instance of emergency for the person to be arrested,
that requirement cannot be made in an instant of extreme urgency or emergency. I take that point. I think that's one of the reasons why I asked that question. But if the arresting officer has the time, the opportunity to go and get the warrant of arrest, then that would be reasonable for him to do. Now, for instance, upon reasonable suspicion, I see somebody is committing an offense. By the time you go and make your application to get your arrest warrant, and you come back, the person would have disappeared. So you discover that some of these letters of the law, some of them are simply, inapplicable to certain situations. But if it's something that is continuous in nature, if it's something that is continuous in nature, one would expect the arresting officer to do what? Go and get warrant of arrest. But we all know that some offenses may not actually be described as being continuous in nature. Take for instance, somebody burgles houses. He can't burgle, time is of essence to him, am I right? He wants to do this and get away. He doesn't want to be caught. Alright. So he comes there, papers whenever he sees, and say, okay, this person is doing it. Maybe he will come back the next day. And then you go and get an arrest warrant, waiting for him to come another day. Now, assuming he comes and you arrest him, as law students, do you think that arrest will be valid? There won't be anything wrong if the act is contractual. You see some offenses that describe, the statute that describe offenses that are continuous in nature. All right. The whole essence of arrest is one. Let me have 3 points. Why do we need to arrest? One,
to restrain the offender from possible subsequent committing the offense.
Any other ones?
Bring him before the court for trial.
Right?
To gather more information about the investigation.
Then to gather more information, there's something I'm looking for. Any other contribution?
To discourage other people from committing such offense.
Any other thing?
To maintain order in the society.
Order, that is one of the duties of the police. You understand? Okay, so we have all said this. So the main essence, one, is to apprehend this person suspected to have, reasonably suspected to have been committing offense or have committed offense. And when he is apprehended, what if during the interrogation we discover that he didn't do anything, that he has not done anything wrong, and that your reasonable suspicion was not reasonable afterwards? So what happens? What happens about the arrest?
False imprisonment.
False imprisonment, what else? I'm asking this question. Let me know whether you still remember what we learned last time. What else? Now, okay, go on.
In such circumstances, if the suspicion is always there, the person is being released and you have not the amount to everything because that alert was just to investigate into the matter and know whether there's another condition.
Okay, that's another angle to it, and I agree. The fact that somebody has been arrested does not mean that his fundamental right has been violated. How do we know whether his fundamental right has been violated or not in that instance? From the example I gave you, how would you know whether his fundamental right has been violated?
If the arrest was conducted without reasonable suspicion.
You see, you don't answer this question with if because you're seeing the case scenario. All right, let's not waste time. The reason for the arrest, that's why the law says reasonable suspicion. So that reasonable suspicion is what? A defense, is a growth, is a cover to the arresting authority. Why? Because the law presumes that this person who is arrested is just being a good citizen. Am I right?
Yes, sir.
He wants to help the society, to ensure there is orderliness in the society, that the property and life are safe. So that's why in the first instance, he went out to arrest. Not that those people, maybe you see somebody, oh, just watch him. He's stealing. Oh my God, he's killing this guy. He has killed him. Oh. You know, these people do skills. Nothing, just record the video and blah, blah. So that's the thing. All right, so the arrested person has a kind of coverage if he falls within the coverage. And what is that coverage? Reasonableness of your suspicion. So when we talk about this, we are not only focusing on the place, we're also looking at judicial officers, we're also looking at private persons, right? Just like you and I. You want to arrest, what is the difference there is the motive, the intention, the reason behind your arrest. If the reason you're giving is held to be reasonable, then this person who was arrested, oh my friend, no problem, we are just like investigating something, possibly you conducted yourself in a manner that subjected you to such suspicion. It does not mean that your fundamental right has been violated in any way. Now, another thing we need to know about this is also, assuming you have this warrant, how do you serve it? When do you serve it? How and when? How? The general rule is that it must be done what? Personally served on the suspect. Now, when you are talking about even personally served on the suspect, you discover that it now occurs with our reason that some offenses can be what? Continuous in nature. You understand? Or maybe this person has committed that offense, but he has not absconded. He is still there. But you have every reason to suspect that is this person that did it. Then you've gone to court, even if it has taken you 2 days, and you have gotten the warrant, and you served on him, I have the authority of so to arrest you. And then he looks at it, maybe follows you. If he doesn't want to follow you, we'll come and we'll talk about that one. So he follows you. What have you done? You have arrested him. Right. Now, when you are reading maybe some of these things, you will come out just and read. It will look like arrest is almost the same thing as arraignment. No. Arrest is different from arraignment. Are you following me?
Yes, sir.
Because when you arrest, you can't even arraign like that, because what would you even rely on? What is your evidence? That's why as a private person, when you arrest, what are you enjoying to do? Take the suspect to the police. The police will now do the case file, doing the investigation, putting everything together, preparatory to what? Arraignment. So if after questioning the person, taking his statement within a day or so long as he does not exceed 48 days, the person is released on bail. And then the police take their time to do some other things they need to do. Like in that kind of scenario, it will be impossible for police to investigate before the arrest, because this arrest has not preceded any form of investigation. In other words, the investigation is now ingrained in your suspicion and act of what? Arresting the person, because it's something that happens spontaneously. Maybe you caught somebody in the very act, breaking somebody's house, stabbing somebody, and maybe at times you see maybe like in a police checkpoint, if a policeman maybe gets overwhelmed by any circumstance and shoots at somebody, you know what the police will do? The first thing they do, they will try to do what? Disarm him. They will decide arm him and arrest him. At that point, that they need to build a case file there and then. No, because it's something that has happened spontaneously. All right. Now, when you serve every day. Public holiday, Saturdays, Sundays, the law allows you to do what? To serve. Why is the law like that? You know, in civil now, you have time and the days you can serve. Not every time, not including public holiday, because public holiday is not computed when you are computing time. Now my question is, why has this law suddenly changed in respect of criminal litigation? Why has it changed?
It's for me, I think it's to ensure that the arrest the suspects will not escape while waiting for. They assume that it happens on the weekend now. While waiting till Monday, the person might have the to escape. So that's the person.
Even if he escaped, is it not the internet period? Can't we use a means of internet to arrest him? So why is this law different? I'm not saying you're wrong though. So why is this law different in respect of criminal proceedings? You look at the society again. It's in the interest of the society. You know, there was this funny scenario. Somebody was arrested. You know, when he was arraigned before the court, they said he pickpocketed somebody at the park, Aba Park. He was arraigned. So when the charge was read to him, they asked him to plead guilty or not guilty. He said, Your Worship, that his only problem is that he was arrested on a Sunday. So as far as he was concerned, that arrest was invalid. He should not have been arrested on a Sunday. But then the law is that you can arrest anytime. Because for this law to be like this, it simply means that it's trying to guide the society. You have a situation where somebody can just do anything, you know, and on a Sunday he's working free, you can't do anything. Maybe before, when you're waiting to get him on Monday, by Monday we won't see him again. Now, what are the contents of the warrant? What are the contents of the warrant? If I were you, what you simply do, just try to, you know, do it in a sequential order. So that even if I have not even seen a warrant before, from what I'm listening to you, I can be able to jump and find out how it looks like. Do you understand? There has to be a heading now. Maybe that heading will tell you that this is emanating from a particular ministerial district or a particular judicial division. The only thing is that you don't have names of parties. Right. Now, if it's a criminal form, you can have from this, in the High Court of this, holding a blah, 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 or a magistrate court. And then the preamble or the introductory part will just be like the magistrate, and just giving you like an example. You know, upon the complaint brought by so, your name now will be there. Somebody who brought the other written or oral complaint to the attention of his worship. You put it out the magistrate. The magistrate hereby commands. The arresting authority will now have to be mentioned. Are you following me? You know. Now, and then after that, to arrest who? The name of the suspect. For what? That's when we bring in the concise statement of the offense alleged against him. You know, and then what other things should be in that document? Okay, the name of the magistrate, signature, stamp, date. Now, assuming that this warrant was issued in January, and the suspect absconded. He couldn't be arrested based on that warrant. And then in September, he had gone home for New Year Festival. Now, the person who had this warrant, do you think that this person with the warrant can use that first warrant issued in February to arrest this person?
Yes, sir.
Everybody's saying yes. Let me know why. Who said no? Okay, let me hear from you first.
I think the lifespan of the warrant is 6 months.
6 months. Under which law?
Okay,
Okay, you are thinking. Okay, no problem. Any other answer?
And that's why it's very not executed.
okay.
It is valid until. So that is the thing. Now, what if after you have used this warrant to arrest this person, and then he goes there, he's released on bail, and you are not satisfied? Can you arrest him again with the same warrant? No. Why? The same thing applies if he commits a fresh offense. The fact that you are still holding the old warrant doesn't permit you to do what? To arrest him based on the new offense that he has committed. Okay, so far so good. That is all right. So let's hear group 6.